Welcome to Inside Employment, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in Australian employment law and practice.
Well, hello and welcome to Inside Employment, which is a new podcast series from the team at Herbert Smith Freehills Kramer that looks at key employment issues and developments facing employers in Australia. My name is Tony Wood. I'm a partner here in the employment team at HSF Kramer in Melbourne, and joined today by my colleague Lucy Boyd. Hi, Lucy.
Hi, Tony. Pleased to be here.
Now, today we're talking about something which is so important to our practice and to our clients, which is the subject of conducting workplace investigations. For us and our clients, we've noticed this incredibly significant trend over the last 5 years at least, where the volume of investigations has increased substantially. And Lucy, I think in your practice as well, you've conducted so many of those. Why is it so important to conduct and ensure that you properly conduct these type of workplace investigations?
It's so important, Tony. A lot has changed in the past 5 years. We've seen a rise in employee activism. There's movements like Me Too, Black Lives Matter, which has resulted in employees having a larger voice about this and being more willing to speak up. That's also been encouraged by recent changes in laws. So we've had the changes in the whistleblowing laws, and we'll talk a bit more about whistleblowing investigations later on in this podcast. But we've also seen the respect at work changes. So the renewed focus, the introduction of the positive duty, which has moved a burden onto employers to take action rather than just responding to complaints or legal claims.
So to take reasonable and proportionate steps to prevent workplace sexual harassment and sex discrimination. So that has been a big part of our practice.
Yes.
So I should say at the outset that we're going to do this session today in two parts. The first part will be examining some of these legal and technical aspects and procedural elements of conducting workplace investigations. But part two, we're really lucky to have one of our external investigators who we use very frequently, Lisa Bradley. So we'll be welcoming Lisa at the end of this session.
Yeah, that's right. That's right. But first, Tony, I guess one topic I'm really keen to discuss is whistleblowing investigations, and we have seen a huge rise in these. A few years ago we had the changes in the Corporations Act to require clients to have whistleblowing policies, and then in recent years we've seen some further attention on these complaints. And in our practice, we're seeing a lot more whistleblowing investigations come through the door. So perhaps to start us off, can you tell me, what is a whistleblowing complaint?
Well, I mean, before I even do that, we're not only seeing our clients conducting more of these investigations, but we're seeing them litigated as well. Or even if they're not litigated, we're getting lots of correspondence letters, complaints from plaintiff law firms, which are often piggybacking onto general protections claims with allegations in relation to the whistleblowing laws. And the key elements of the whistleblowing laws are that there needs to be confidentiality of the process, non-disclosure of the identity of the whistleblower, and secondly, the protection of that whistleblower or the person who might be assumed or purport to be the whistleblower from any detriment or disadvantage or victimisation. So we're seeing a lot more claims from the usual suspect law firms, without judging them at all for that they're combining these type of claims with general protections claims. So the volume of those, and because we're seeing also more litigation in that space. And, there's some celebrated litigation in the Terracom case. We might talk about that a little bit more later on. But your question to me, sorry for the rant.
Yeah, I'm asking you about the law. Tell us.
We're still asking about the law. That's complicated. Well, first of all, there are a number of elements that go to whether a complaint is afforded the protection under the Corporations Act. First of all, the first element, the complaint has to concern a disclosable matter. There has to concern either fraud or what's called in the legislation an improper state of affairs within a business. And it can't pertain to what are individual, personal, workplace-related grievances. So first of all, it has to fall within that domain. Secondly, for protection, the complaint has to be made to an eligible recipient. number 2, and that eligible recipient will be a senior officer, a lawyer, or a person identified as a senior manager within the company's policy. And thirdly, it needs to be made by an eligible whistleblower. That is someone who is either an employee, a former employee, or a supplier or contractor, or a relative of one of those categories of people. And assuming those 3 elements are satisfied, then a complaint is a legitimate or valid whistleblower complaint.
That's right. And I think, when we hear of clients, that's the first step we take is to check whether all those elements are satisfied. I am interested by one comment you made there that personal employee grievances can't be whistleblowing complaints. And I'll just pick you up on that, Tony. I don't think that's exactly correct. So a personal...
Would you like to refilm this part?
No. A personal grievance could be it's an exception, but it could be a whistleblowing complaint where it's a grievance that doesn't just impact the employee personally, but has broader significance to the organisation.
Which would grow into a so-called improper state of affairs as well.
That's
and
right.
One of the complexities of the legislation is actually to determine whether a matter is a personal workplace grievance or not. We spend a lot of time agonising that, and clients agonise over that in particular. So quite clearly, if I'm concerned about the Tim Tams at lunchtime, or the fact that you might have misspoken towards me, or more likely I've misspoken towards you, those elements are very unlikely to constitute an improper state of affairs or fall within the scope of an eligible complaint. However, you might get into broader issues, systemic issues associated with discrimination. There might be gendered approach to remuneration within a business. There might be some kind
underpayments.
Or any of those kind of issues, underpayments, which, although I may have a grievance as an individual, relate to a broader array or class of employees that could fall within an improper state of affairs, or more broadly within criminality and the like as well, particularly as in relation to wage theft laws, which is now a criminal offence. So it's often hard to determine whether a matter falls within, but in any event, I take this approach. We know if you make a grievance, or I make a grievance, it may fall within the category of protection as a whistleblower complaint, but at the very least we know I have probably made a, quote, complaint or inquiry in relation to my employment. And that is a workplace right under the Fair Work Act. And because of that, that is also afforded an element of protection under that Act, which means, for a start, I can't be subjected to so-called adverse action, which is the equivalent to victimisation or detriment for the purposes of the whistleblower laws. So one of the practical pieces of advice we give to our clients is don't get hung up necessarily on whether it is or it isn't a valid complaint within the Corps Act. Is it a complaint or inquiry? Because mostly the processes that you're going to adopt are going to be very similar. It's subject to the fact that even if it is a complaint or inquiry in relation to your employment, or a protected complaint under the Fair Work Act, you're not going to go out sprouting the identity of the complainant. So you might make a safe assumption that it could be a Corps Act complaint, and then treat it accordingly in full knowledge that you can't subject the employee complainant to detriment under either elements of either the Fair Work Act or the Corporations Act.
That's right. I think that's a sensible approach to take, noting that there's no bar on claimants or bringing both types of claims, so you could potentially be on the hook for both.
Yeah, and with the other similarity, by the way, in this respect, is the burden of proof. Clients are well and truly aware that in relation to general protections claims under the Fair Work Act, there's a reverse onus. You need to prove that your conduct was taken for a reason which is not an unlawful reason. Otherwise, you can find yourselves in all kind of strife. And that's virtually the same test as a Corps Act, isn't it?
It is. And again, it looks into that substantive and operative reason for taking the adverse action, or in the case of whistleblowing laws, the victimisation. So it is the same. And the other point is that in both cases, if you find yourself in the unfortunate position of being in litigation, sort of inevitably the decision maker will need to be called to give evidence.
Yikes. We don't often want that to happen. Hey, look, maybe taking the next step, Lucy, just kind of given this really very broad array consideration of whistleblowing complaints. In your practice, which is very similar to the kind of work that I think our team is doing across the country, what are the main types of investigations that you're seeing anyway that would occasion an employer to conduct some form of an investigation?
Well, I think they fall into three key categories. There's your classic sort of breaches of workplace behaviour policy, misconduct type investigation. So bullying allegations is a huge one, and I'd say probably the majority fall into that category. Other is sexual harassment and related misconduct is another very frequent complaint that we receive. And then in another category, which we're not going to talk about today, but is a workplace health and safety incident type investigation, which we won't talk about because there's a different regulatory landscape for that, and it may be that you're conducting a workplace investigation in parallel to a regulatory investigation, and there's all sorts of other inquiries that our Inside Safety podcast will no doubt go into.
True, but there is a lot of overlap between WHS investigations, and particularly the regulators may well be investigating bullying complaints as part of their psychosocial health areas, or bullying. Even sexual harassment grievances could fall within the array of the WorkSafe or the relevant state regulators in that space.
Yeah.
I suppose it's much more fraught, the type of WHS investigations, when we're looking at an incident response.
A physical
incident response. A piece of machinery malfunctions, someone is injured physically at work, they might have lost a limb or even worse. Those kind of investigations will put aside for the purpose of today's conversation, because those may well be conducted in tandem with the regulator, and what you might as an employer try to cloak with legal privilege in terms of your own investigation may not be legally privileged at all. There are different considerations. So I think it's a good idea.
One for another day.
We'll park that one later on. Can I just say one of the things that you're probably going to get to is what I'm seeing a lot more of, which are either cultural, what we call culture reviews. A lot of employers hate that term, but it's a broadly described term into looking at kind of red flag issues that you might as an employer identify. There might be
attrition,
a spate of grievances. There might be a high level of attrition in a particular location. Maybe your employee surveys indicate that there's a high level of discontent within a particular area. And often those will be associated with some tension or complexities. So again, you've seen that as well?
More and more. And I mean, even in the public domain, we've seen multiple examples of that. Liz Broderick's done quite a few public cultural reviews into certain organisations. So it's definitely becoming more and more common within the past 5 years. And part of that is the introduction of the positive duties, which requires employers to take that proactive stance and have systems in place so they can pick up issues before they bubble to the surface and become complaints, or to stop the conduct from occurring before they're dealing with the more complaints. So the key difference between a cultural review as compared to your more typical workplace behaviour type investigation is that a workplace behaviour investigation, the catalyst for that is usually a complaint being put into your systems, or being reported up, or there's usually a complainant and a respondent or an alleged perpetrator. Whereas with a cultural review, it's more of something's been bubbling under the surface.
Inquisitorial investigation rather than a respondent and a complainant in the normal sense.
And it may result in, yes, there might be findings, but it may not be in relation to just one person's conduct. It could be broader than that there's, systemic issues with certain matters in particular working groups. And another example of where we see this is where maybe a particular subset of a business isn't performing well, or something's just not right there that requires a further investigation.
And I think there's some really good examples that our clients or people watching or listening to this podcast can do some interrogation. You mentioned Liz Broderick, for instance. I think she authored the report at EY
Yes.
into some cultural issues in terms of working hours and the transparency of that organisation. And all kudos, by the way, to EY, who accepted Liz Broderick to conduct that report and to have it published on her website and their website.
Yes, that's
and
right.
It's a bit warts and all, but it's a great indication, I think, of what we're seeing more broadly in the community and amongst our clients, a greater acceptance of accountability towards their staff and also to their clients and others. To say,
And their investors as well.
yeah, that's right, shareholders and so on, to say, yeah, this is what we've done. And I think similarly, looking at some of the investigations in the mining and resources sector in response to workplace sexual harassment,
Yes.
particularly in cases where there is has traditionally been a gender disparity in those sectors.
Yes.
And some of those reports are publicly disclosed, and there's some quite willing findings about there that I know from some of those clients has been really difficult, cathartic, and really important for them to be able to make progress. And hence, these kind of cultural reviews, I know it's a big category to lump it into, have been pretty successful.
Hugely successful, and signifies that seismic shift that we've seen in 10 years from, 10 years ago, it was still sort of, you'd receive one of these complaints and a lot of the time clients didn't want an investigation or they wanted to cover it up. They wanted a settlement agreement, whereas we've now sort of moved to transparency. And one of the great benefits of that is the industry learnings that can be had from sharing these kind of reports publicly with a shared goal of reducing this kind of terrible behaviour.
And we'll talk to Lisa Bradley in the second part of this podcast about her experience, but I reckon it will be similar to what you just said, Lucy, and I agree. I've been doing these for many, many years. I would say that in the last 10 years, there's been that absolute pivot towards greater transparency and accountability, and by no means yet perfect, by the way, but certainly 20 years ago, I would have been much more likely to have been instructed by a client to say, we've got a grievance, this person's a troublemaker, how can we exit them without necessarily having to conduct an investigation, certainly a transparent investigation. Yeah. So big changes.
Huge changes, and I think it comes from growing awareness of the impact, the harm that these behaviours can have, and not only the harm on the individual or the victim impacted, but the harm on business as a whole and culture and productivity.
And reputation. I mean, we've seen many instances of this in the last few years where there have been either whistleblowing complaints or grievances which have been agitated in the public domain. And very often those, it's death by 1,000 cuts. It might be a CEO who's been accused of improper conduct and has been subject to investigation, maybe not properly addressed within the business, and the media gets hold of it. And once the media has hold of it, it takes a life of its own. So clients are much more inclined to understand that and get in front of the problem and stop the bleeding, before it gets worse.
Yeah.
So it's a good example.
Completely agree. Now we could talk all day, but should we focus on? So we've spoken about these investigations. So how should clients be dealing with them? There's different ways to do investigations. You can keep it in-house. You can do it external, legal privilege or not. What are you seeing, and what's the best way to solve the problem?
Well, I mean, we conduct a lot of investigations for our clients ourselves, and generally that follows a kind of a triage process, either that the client themselves will conduct or that we'll conduct with them. And you'll look at the scale of the issue, the significance of it, the number of employees involved. We'll look at whether the client's got the resources to conduct an investigation. An investigation of scale is often very hard to be conducted, in-house. But then again, an individual or a grievance about a particular misuse of credit cards or the like might quite easily and simply be investigated forensically internally without necessitating an external investigator to become involved. So you'll triage it first of all. How serious, how big is the scale, what's it likely to involve, and is there someone within the business who can investigate this with an element of independence without having the conclusion being impugned by those kind of allegations.
I think that's right. And I think what's really important is, you can have the best made plans, but it's important to be nimble, because there are certain matters which will require external investigation. If it's a really senior individual and there's necessarily going to be conflict from someone conducting it in-house. But then there's other matters where if you immediately jump to a formal external investigation, it's going to completely elevate the issue beyond what it needs to be, and it's going to create more harm to those involved than not. So
I say this to clients all the time, that you need to be careful what you ask for, and understand that when you conduct any form of investigation, it's most likely going to get worse before it gets better. And certainly the timing issues can elevate the issue as well. So be prepared to understand the impact that those things can have. And secondly, as much as you might want to control the confidentiality of that process, it's almost impossible to do so, because people might be directed to say this process is confidential, I'm not going to disclose anything, please sign this document that you agree not to disclose any of the content beyond this meeting. And next thing you know, half of the floor of the building is talking about it. Hey, did you attend that meeting with the investigator? What did you say? And so on and so forth. Now, it's really hard to control that. So sometimes it can be just as easy to get the CPO or even the CEO or the general counsel within a business to try and deal with that matter, or the chair of the business as well, to get to the cut and thrust of the issue. And sometimes there might be a mediation option as well, which is separate to an investigation. It all requires nuance. I mean, Lucy, you might have been involved in one when I did with a client recently, a global business with some Australian operations. And there was a really complex issue of a senior female employee having issues with the CEO. And that could have been investigated. There were elements of the complaint that she made that were at one end of sexual discrimination or sex discrimination potentially. On the other hand, there was a very clear feeling that person wasn't being listened to, weren't being given opportunities. And the client, to their credit, flew out their CPO, a global CPO, and worked through the process through listening, a general, very nuanced form of mediation. And it's that kind of triage process that you need to go through to make sure you get the right process.
I think that is very fact specific and individual specific as well. Like, what is the complainant seeking? Is it a form of justice? Are they looking for an exit from the business? Do they, do they have an axe to grind? But it requires very nuanced thought, I think.
And sometimes, conversely, the allegations are so serious that you have no choice.
That's right.
You have to conduct an investigation into the relevant issues. And frankly, that's often when clients will come to us and say, not only do they want us to help them with that investigation for an element of independence and the capacity to do it, but also to cloak the investigation under legal privilege. That is, to ensure that the findings, that they engage us for the purposes of making findings of fact and law, to understand their liability and exposure and risk, so that then they can make an assessment on what steps that they may take remedially to address the issue. So legal privilege can be an important element of these kind of investigations.
Yeah, and that's not to say that you may not ultimately choose to waive that legal privilege down the line, but it is certainly has its place in investigations, particularly where there might be broader organisational issues that they require legal advice on.
So when we talk to Lisa in part B of this session, we'll be talking about some of those really practical issues that Lisa confronts in terms of, as an investigator, how does she make those findings of fact? Again, harking back to the old days, it used to be he said, she said, okay, that seems plausible, and therefore make a finding of no determination at all. And I'm sure we'll hear from Lisa talking more about how to granularly make the assessment of merit of a complaint and the facts, and also how I think she approaches the situation where you might have a complainant and a respondent, and the element of care that you have for the psychosocial health of all of those people. So that will be interesting talking to Lisa as well.
It will, certainly. I think probably that's all we have time for today.
I could talk on forever, but thanks so much, Lucy.
Thank you.
We'll be meeting soon again with Lisa, and we'll go through some of her practical experiences. As usual, if anyone has any questions about any of the content or would like to make contact, please follow the links that are available to you to our Inside Employment podcast series, and we look forward to getting some feedback from anyone as that process is continued.
Thanks for joining us, and see you for the next instalment.
Thanks, Lucy.